Leah.
Good afternoon and welcome to a meeting of the Family, Children, and Custody Subcommittee of the California Paraprofessional Program Working Group. I can begin by taking roll. I don't believe Sharon Bashan or Stephen Hamilton are here, have joined us yet. McRae?
Here.
Olvera?
Here.
Sarouche?
Here.
And Judge Wiley?
Present.
Okay, and I can see, so Fariba, should we start with public comment?
Well, let me just make a few statements just to kind of set a roadmap here. So today our meeting is 2 hours. We have a lot to discuss. We obviously have the child welfare issues to discuss, and I understand we may have a lot of public comment on that. And then we have other outstanding issues under the family law topic that we need to discuss, educational requirements, just quickly discuss excluding minors counsel work as an authorized task. We somehow forgot to add elder abuse as a part of the violence prevention work. And I want to quickly discuss enforcement of judgment as an issue. And of course, whether we want to contribute anything specific to the informed consent and disclosure forms. So I was thinking that we start with public comment. We do it for 20 minutes, 3 minutes each person, depending on how many, because that only gives us room for about 7 speakers. If we have more, I'm going to have to cut that down to 2 minutes, and that'll give us 10 speakers. And then I want to move on to the other issues from child welfare. About 45 minutes to an hour in. I'm hoping it's not going to take that long. Then we have two panelists here. Thank you so much for joining us. Amanda Kennedy from Santa Clara County Law Foundation's Legal Advocates for Children and Youth. And we have Leslie, forgive me if I mispronounce your last name. Is it Himov?
Himov.
Hello there, from Children's Law Center. Is that in Los Angeles then?
We represent all of the children in Los Angeles, Sacramento, and Placer.
All right. Good to have you both with us. So with that, let's start public comment.
Okay, so if anyone would like to make a comment, please raise your hand. I see a couple of hands going up. So far, there's just 2. So
oh, cool. Then 3 minutes.
Go ahead and, okay, great. We have Mingyong Lee.
Hello, everyone. My name is Minyoung Lee. I'm a senior family law attorney at Neighborhood Legal Services of Los Angeles County, and I work with survivors of domestic violence in low, no-income communities. And prior to that, I did practice in juvenile dependency in Los Angeles as a court-appointed attorney, parents attorney for about 8 years. Thank you so much to the subcommittee group for the work and time that you've put into this so far. I know that this group has had to address so many different topics, and I've witnessed how much effort has been put into this. And I understand today's meeting will largely be addressing the juvenile dependency issues, and partly because of CLC's letter that has asked this group to take another look at whether or not this new paraprofessional program should apply to this area of the law. And as one who has practiced in one of the country's largest child welfare system for many years, I experienced firsthand the very things that this group has addressed. So when the group talks about parents who need to deal with social workers prior to cases being filed, or parents who have filed a 388, these aren't just hypothetical situations. I picture my clients, mothers, and fathers who have been in this very situation. The child welfare system is absolutely, under no uncertain terms, a desperate one. It disproportionately affects families living in poverty and minority communities. So this group is putting forth recommendations to create a for-profit industry that, by the very nature of its creation, if allowed to have any place in dependency, we're opening it up to communities that are most vulnerable to predatory practices. And I would argue that there are many layers of systemic injustices that are built into the system already, and that to consciously create yet another layer would be truly unfortunate. I know that the task for this group isn't to come up with other alternatives other than what you have been asked to do. But I would ask that you would consider the larger picture and that we do not lose the forest for the trees. Paraprofessionals without fee caps being paid money to fill out forms for clients, or help a parent get records, or sit down with a parent at a 388 hearing to help manage their emotions is simply not the answer. And I would ask that this group not include any area of juvenile dependency for this new program to allow the systems in place to come up with alternatives that provide meaningful, free services to families who are facing the trauma of separation. Thank you.
Thank you.
Thank you. Now we have Michelle Pena.
Good afternoon. My name is Michelle Pena. I am an appellate attorney in dependency and also mental health law. I've been an attorney for 6 years. Prior to that, I was paralegal for 8 years, 4 of those also in law school, working as a law clerk. And in 2007, I worked with the Center for Community Solutions with the Domestic Violence Clinic at the Family Justice Center, and also in the El Cajon Courthouse here in San Diego. And I absolutely echo what Ms. Lee was just discussing. I just wanted to note that I concur there are gaps in justice, in access to justice in this area. My concern is that they be filled with access to equal justice. I am concerned that as a paralegal, I knew very much about dependency law, but I learned so much more as an attorney after having gone through law school and worked side by side with many experienced attorneys who to this day are also still learning about this system that changes. There's always new law to stay abreast upon, and that's why we have our MCLE requirements. So if this does become a profession, I absolutely hope that the education requirements are enforced and are similar to that of an attorney, that they are required to stay up to date with the case law. But my concern remains that, do we really need to have a new profession or fill in these gaps in justice with supplementing funding to the already existing legal aid services? There are family law attorneys that do low bono work. Perhaps there could be a way to have a program in the state bar that would have a way for people to access those attorneys, like a referral system. At the end of the day, though, my concern is access to equitable justice. And even if there are reduced fees, that the expertise and qualification required to represent these people, it's immense. And that consideration be made, especially with dependency. And even when there's situations where it appears on its face that just about filling out forms, or if something is a matter is uncontested, that doesn't necessarily mean that there are not more complex issues just hiding under the surface. Thank you for your time.
Thank you very much. Are there any others?
Yes, we have Donna Kaiser.
Hi there.
Hi, can you hear me?
Yes,
My
we
name,
can hear you.
Yeah.
My name's Donna Kaiser. I'm in San Diego. I'm an appellate lawyer. I do dependency law as well. I know Michelle very well. We've talked about what this committee is working on, and we're exceedingly alarmed. I've been doing appellate law representing parents in dependency cases, just that, for the last 22, 23 years in California. Before that, I was a public defender in Maryland and Baltimore City. For 10 years, I did trial work. From 1982 until 1992, I then did criminal defense work as a public defender. The whole time I was in Maryland, they were trying to get rid of, trying to undo dependency lawyers in dependency cases. And I can see that it's still happening out here, but you can't do that. There are constitutional rights at issue. Paralegals are not competent to do this work. I have 30 years of experience in doing this work. I am still learning every day something new. I find it very, very, very complicated. You have no idea. Paralegals cannot do this work. Recently, in the case of, and the lawyers in the trial courts are barely doing a competent job, quite frankly. And that has been commented on by the presiding justice of our California Supreme Court, during oral argument in In Re AR at 11 Cal 5th 234. If you listen to that oral argument, the Chief Justice commented on testimony before the legislature complaining about the overwhelming caseloads of the dependency attorneys in the state. The existing system needs to be helped. You need to help provide more attorneys, better training for the attorneys that we have. If you try to undo what we have and try to give this to someone who's not trained in
30 seconds remaining
facets, you're going to be undoing parental rights in the distance after children have supposedly been adopted, and those decisions are going to be overturned because there have been violations of their constitutional rights. That's not what you want to do.
Thank you, Ms. Kaiser.
Thank you.
Are there any other speakers?
No, there's nobody else who's indicated an interest in speaking.
All right, thank you. All right, we'll get started. So I'm just going to ask to start with our speakers. Doesn't matter who wants to go first, raise your hand. So why don't I ask Ms. Kennedy to go first and tell us about what you hear to your position, just a little more about what agency and what kind of work you do.
Certainly. My name is Amanda Kennedy. I'm with the Law Foundation of Silicon Valley, Legal Advocates for Children and Youth. We practice in a variety of youth-focused law. I'm here because I'm our supervising attorney of our juvenile dependency unit. I'm also here on behalf of Dependency Advocacy Center in Santa Clara County. They represent the parents and the small portion of children in juvenile dependency for which Lacey has a conflict. They unfortunately were unable to have someone here today, but they asked that my comments also be considered as part of their comments as well.
And Ms. Kennedy, and I apologize for interrupting. I'm just noticing, and I chair this working group, by the way, which is why I'm feeling free to butt in. I'm noticing that Mr. Stephen Hamilton has his hand raised. And Stephen, I just wanted to check, was there something that you wanted to say before the speakers began?
You're on mute.
If possible, I had written a memo about the Minors Council issue. I think that's a really quick discussion and I have to leave early. So if for any reason we're not done with the speakers and I can't address that issue by, let's say, 4:15, I would be in trouble because I have to go. All
right.
Thank you.
Thank you. I'm hoping to be done with this topic by 4 o'clock. Go ahead, Amanda.
Thank you. So with that introduction, Lacey and DAC would respectfully urge this committee to defer its vote on the recommendations as to child welfare until more practitioners in our child welfare community have had an opportunity to provide input. And we appreciate that this committee has considered input that child welfare is a nuanced area of law, and that it does differ from other types of family or child custody practice. But because of that, we believe that it's important to receive feedback from a broader cross-section of California's child welfare practitioners before making any decisions. And if this committee were to adopt recommendations allowing paraprofessionals to practice in child welfare, we believe that it is imperative that there first be training requirements developed, which would ensure informed and competent practice. And I mentioned the nuance of dependency, so I just want to return to that with a few examples. In juvenile dependency, there are very strict legal timelines governing our cases, stemming from both federal and state law. There are also specific noticing requirements at different stages of the case, and those pertain not only to the parents, but also to children, attorneys, relatives, Indian tribes, child advocates, and others. So it's pretty complex. Also, juvenile dependency cases are confidential, so there's really not very much opportunity for the public to observe the cases and to familiarize themselves with the procedure. Further, there are multiple parties involved, not just a petitioner and a respondent. In each case, we have potentially multiple parents because each child can have 2 or more parents. Every child is involved in the case, and there's a county agency. And that's important because in every dependency case, the petitioner is a government entity, not a private citizen. Also, and we've heard a little bit about this already today, but the law changes frequently. In almost every legislative cycle, there are changes to the statutes that impact child welfare practice. And these are very highly appealed cases. So there are dozens of published appellate opinions that come out every year that one has to keep on top of. So we did note that in the proposed recommendations of February 26th, there were recommended topics of training and experience for the violence prevention work. And we firmly believe that similarly, there would need to be a robust training regimen in the area of child welfare. Dependency practice is a little bit unique in that the parties in a dependency case are entitled to competent appointed counsel, regardless of their income. And there are really complex reasons for that. It's a niche area of law. In many geographic areas, it's difficult to find private counsel with dependency experience. There are these strict timelines. We're looking at children's needs and their safety, and that needs to be assessed by everyone involved. And people need experience to know how to do that assessment. And most importantly, there are fundamental rights at stake. So if paraprofessionals are permitted to engage in child welfare practice, it is of utmost importance that they receive very specific training in order to do so competently. I thank you for your time and consideration and having me here today. And of course, if there are any questions, I'm happy to answer.
Thank you. Yes, I will definitely have questions. Okay, Leslie, thank you so much for waiting and thank you for being here.
My pleasure. Thank you for setting this time for us to be able to talk with the committee. So just quickly by way of background, I am, as I said earlier, the executive director at Children's Law Center of California. We have represented all of the children in LA County for just over 30 years. We are about to celebrate our 10-year anniversary in Sacramento County and have been in Placer for 3 years. So we have the experience of representing children in the largest county in our state and in one of the smallest, as well as a medium-sized one. Although Sacramento likes to think they're small, they really are medium. I personally have worked in this arena for close to 40 years. I was a social worker and worked in residential childcare before I was a lawyer. And I began my career 30 years ago at Children's Law Center. And at that time, we were called Dependency Court Legal Services, and we represented both parents and children. So for the first 6 or 7 years of my full-time practice, I had a mixed caseload of parents and children in the LA County dependency courts. And then for about the past 20, we've represented only children, or primarily children. We represent young adults that are parents, youth in foster care who are parents themselves. And we have a multidisciplinary practice, meaning that we include within our law office we have over 100 social workers who are employed by CLC, paralegals, youth with lived experience who serve as peer advocates. So in some ways, our practice does incorporate some of the ideas of having a paraprofessional involved in a dependency practice. And I raise that because we have learned over the past 10 years since we hired our first peer advocate that there is a value to having folks other than an attorney involved in the case, but without the legal expertise and without the close supervision and support and guidance of a trained attorney, their ability to be a positive influence in the case is significantly reduced or limited, shall we say, for many of the reasons that Amanda pointed out, as well as some of the reasons that the folks in public comment pointed out. Specific to the 2 recommendations, I appreciate that that your recommendation is already fairly narrowly tailored in terms of what the roles of the paraprofessionals would be, but would add that even for me reading it, I'm not clear what they would do. So I think that's one of the problems is that, and I'm hoping the committee can take more time to flesh out exactly what they would be doing. And I'll start with the first bullet, which is that paraprofessionals are not authorized to represent parties, which we think is good, but that they are authorized to sit at counsel table to support and advise their clients and may answer direct procedural questions. And then, as I understood it, but then earlier on, I'm sorry, it says that they're authorized to assist parties in juvenile dependency cases who are not entitled to court-appointed counsel. So every party in California is entitled to court-appointed counsel. So I don't know if it's just a wordsmithing problem, but there are no parties without a lawyer in dependency cases in California. And they're free. We are state funded. And fortunately, and I don't know if Ms. Kaiser is aware of this, in the past 7 years or so, the legislature and the governor have seen to it to really significantly increase our budget so that our caseloads have reduced and continue to reduce to allow us to provide the highest quality representation possible.
Leslie, I don't want to interrupt. I just want to say we were referring to the JV 180 or request to change stage. And okay, my understanding is still that any interested party can file this form, but only parents and guardians, if I'm not mistaken, have a right to appointed counsel, but not, for example, necessarily siblings or if another interested person like a relative.
Sure. So thank you. And so maybe it's just the use of the word party being used interchangeably. There are people who can file a JV 180 who are not parties, which would be, for example, an interested relative, a sibling who themselves does not have an open child welfare case. And so those folks would not be parties, and that's why they would not have, maybe it's interested persons might be the better word, just to reduce that confusion, because that was very confusing to all of the dependency folks who looked at these recommendations. And I think the pre-filing work and I don't know that I have a strong objection to someone helping someone, a relative fill out that form. I guess the bigger question to me though is whether that is necessary. The forms are very self-explanatory, and in any dependency case, typically those interested persons are either there because they're interested in the child or they're there because they're supporting the parent. And in our practice, and I believe in throughout the state, they would have access, for example, to the minor's attorney. If a relative calls our office and says, I'm the auntie for your client and I'm interested in establishing a relationship or strengthening my relationship, I want to be a visitation resource, I want to be a placement resource, the minor's attorney will be thrilled to speak with that person and will work closely with them to make sure that they can get that form filed and that they are heard when they need to be heard in court, and that we can connect them with the social worker and all of that so that they can become involved in the case if they're there to support or interact with the child in some way. And then similarly, parents counsel would do the same for parents, for relatives that are more connected with the parent than the child, perhaps in a particular case. I think that to the point about training, if I'm understanding, I read the training guidelines, and if I understand them correctly, they're less onerous than the training requirements for an attorney practicing in dependency court. Our lawyers have to have 8 hours of training before they can even set foot in a courtroom, and then 12 hours annually. And that assumes that they're supervised by an attorney supervisor and that they're working typically in a law office practice where they have access to all sorts of professionals and experts and people with decades of experience providing supervision on a case-by-case basis. And they have a cadre of colleagues that they are discussing the more complex cases with, issues of first impression, et cetera. In addition to the the training that's required by the rules of court, for example, again, most of our law offices, Amanda's, mine, many of the others, we provide no less than 2 to 3 trainings a week that are available to our attorneys, and upwards of 20 hours of training that's mandatory on top of what is required by the rules of court. So I think rigorous training is absolutely essential. And if I'm understanding the training guidelines, I don't think it's unclear how they would meet to that level, how they would meet that level of training for the paraprofessionals. I also wanted to comment on the folks sitting at counsel table. There is a need for pre-filing assistance for parents and guardians who maybe have an interaction with a social worker that may be leading to the filing of a case, and they want some advice or assistance prior to the case being filed. Whether that needs to be provided by an attorney or could be provided by a paraprofessional, I think remains to be seen, since it's a very new area of law just emerging around the country. There's maybe a half a dozen places where that type of legal service is being provided, but it is being provided by lawyers. New York City, New Jersey, or Washington State has a program. There's a handful of programs. They are very new and they are proving themselves to be very effective, but they are all run out of law offices. What is unclear to us is what would happen when we got to court. For example, if the parent had been talking with or working with a paraprofessional prior to a case being filed, and then a case is filed and a court appointed an attorney and an attorney is appointed for them, what's the relationship between the paraprofessional and the attorney? And how does the parent navigate that and move forward through that? Again, keeping in mind that their attorney is at no cost to them, typically, unless they're in the 1% of our clients who actually don't meet the threshold for receiving free counsel or receiving court-appointed counsel without a reimbursement. So I think there needs to be more time spent understanding that relationship between the paraprofessional and the court-appointed attorney when a case is filed. The parent may have developed a relationship with the paraprofessional, but that person might not be the best situated to continue to advise them if there is a case filed. And now they have had their children potentially removed from their care or at risk or are at risk of having their child removed from their care. I'll stop there and take a breath. Maybe I could probably keep going and going, but I will.
No, very helpful.
I will stop.
Thank you, Leslie and Amanda. So I've also talked with expert Andrew Kane, who is, Amanda, is he the director? I don't know anymore.
Mm-hmm. Yes, Andrew Kane is the director of Legal Advocates for Children and Youth, so he oversees all of our youth programs at the Law Foundation.
Yes, and he's definitely a dependency expert, years on California, on Flexcom, and our juvenile dependency expert. And then I also spoke to Hillary Cushins, who is a parents attorney in our area, and all of them are part of the statewide group, so they have a lot of conversations. So let me clarify for my subcommittee members what task we're looking at. Let me just review. We're looking at pre-petition work, and that's communication usually with DFCS, with the social worker. There's no case open yet. My understanding is my understanding now, after having talked to more experts, is that this is a very sensitive stage, because at any time the social worker can decide to open a case. And once they open a case, they're involved in the juvenile dependency system. So the position of the folks that are, as I understand it, that are concerned here is if the paraprofessionals are properly trained on how to, not only how to communicate to the social worker, but also not understand the issues involving this, what caused the destabilization of this family. There could be substance abuse, there could be child abuse, there could be domestic violence. Also legal crossover issues, such as should there be a guardianship to keep these folks out of the dependency system? Again, this is all from a little bit my own experience, because I do come across juvenile dependency cases in my office as well, in my practice, but also with the experts. So there has to be so the question is, what role will the paraprofessional fill at this stage? And what's the training that they should get to be able to do this work competently? And again, we just heard from both Leslie and Amanda what issues are involved. Then there is the, and also I want to just highlight what Leslie just mentioned, and I heard from Hillary Cushins as well, that there are pilot projects right now, like the ones Leslie mentioned in New York and state of Washington and New Jersey. Also, we have one in our county they're testing, appointing attorneys to help at the pre-filing stages. It's not in every county, but this is where we're heading. There's a recognition that the issues, the legal issues involved at this stage are so important that there should be right to appointed counsel here as well. The second category of work is that request for change, right? So case is open, paraprofessionals out because now the case is in court, but JB 180s are the requests for change. And this is my understanding. We help with that. Parents can file those, siblings can file those, interested people can file those. If the case was closed on, based on a guardianship being appointed, guardians can file because it's not technically exited into a family law case, but still open. And if there's a change in guardians, that new guardian can file. Again, this is my understanding. And not everybody has a right to appointed counsel at this time. That's my understanding. So we're looking at what's involved. Should we even allow that work? Should we limit it to completion of forms? Because at the Self-Help Center, this is my experience here at the Self-Help Center. I've talked to some colleagues across the state that when parents, for example, go to their former attorney, the attorney says, I'm out of the case. You can file this on your own and then you'll be appointed counsel. So the filling out of that application, which is, I agree, it's very simple, but parents, and you guys can confirm this based on my experience, are not in an emotionally well placed and not functional enough to tell their story in an effective manner. However, my understanding is as long as they say something and they file it, they get a court date, and appointment of counsel for parents at least is sort of automatic. And then the attorney can take over and then fix things and then communicate the information to the court effectively. So that's JB 180. And if so, the question is forms only, form plus a presence in court, at least at the first hearing, and the continued presence in court if for those applicants where an attorney is not appointed. And then the third category of work is request for records under Welfare Institution Code 827, and whether that's the type of work that we can authorize paraprofessionals to do. Is it relatively procedural and can be, learned? And there are some people who could use that kind of assistance and be willing to pay for it rather than go through the bother of figuring out themselves, unless there's some other assistance available free and readily available free. So those are the three stages we're talking about. Leslie and Amanda, do you have any follow-up comments now that you know what we're looking at? Now I want to open it up to my subcommittee members for questions, discussions, and you guys stay because they may have questions for you too.
Can I ask a quick question about the 827?
Go ahead.
Who other than a parent or a child are you envisioning, or who are you envisioning would hire the paraprofessional to file a records request under 827?
Well, whoever has access. I understand that parents have access.
So they don't need to file under 827 because they get their own file.
Right.
Okay.
They just have to ask the court clerk for it. That's why I'm confused.
Reba,
Tell me.
so parent of a child from a different relationship wants records regarding abuse committed by a parent that was subject to the dependency proceeding and has to file an 827 petition. They are not entitled to counsel, and they are going to get run roughshod over by county counsel if they don't have some assistance.
Thank you.
They run roughshod over me in my family law cases, so I pity the person that doesn't have help.
Thank you, Steve. Any other follow-up comments, Amanda and Leslie, before I open it up to now that you know the three distinct areas we're talking about here? Okay, so subcommittee members, let's talk.
So I do think what we were proposing was really limited. It was not going to give the right or for a paraprofessional to represent anybody who is entitled to counsel. And not in every case would the grandparent or aunt who might want to assert custodial claims be recognized by minors counsel or the parents counsel. They may view that as a contrary position. and will not necessarily adopt, let's place the child with the grandparents or whatever the extended family member is. And they're not entitled as a matter of right. And they would become parties if they requested and were granted joinder in the case. And they would need some assistance, we think, in doing that. That's what we were gearing towards. The only time you would see a paraprofessional in family court is someone who's not entitled to appointed counsel, technically could be a party through a joinder, but needed assistance in presenting their arguments, which may be inconsistent with what was being argued by minors counsel. But it was going to be that limited role. We were more looking at it, I think, in terms of making requests for information, assisting with records requests under 827, the pre-filing requests, assisting people with safety plans before it had progressed to court. That's kind of what we were looking at. So do you see any issue with paraprofessionals helping in those three areas, subject to the proviso that whatever rules are applicable for attorneys to appear and represent parties in dependency court have to be made applicable to the paraprofessional if they are going to appear in family court?
Is that a question for speakers?
Absolutely.
Okay.
And by the way, Amanda, will you tell Andrew I said what up? I gave him a shout out in a memo today.
I sure will. He's out of the office, which is why he isn't here today. Okay. Regarding the records request, I can speak to that a little bit in our county. So in our county, I think that it would be very important that if it were a paraprofessional who were making that request on behalf of anybody, whether it is a party to the dependency case or someone else seeking to obtain or use or release that information, it would be very important that that person really have the training. And I know I keep harkening back to this training piece, but in our county, our judges will sometimes issue an order of inspection. So prior to actually releasing documents or allowing them to be used, they will allow an officer of the court, an attorney, to inspect the file and then amend the request to make a more specific request under 827 once they've seen it and know exactly what pieces of information they need or need to release. Our judges assume that attorneys have a certain amount of training, can understand the written orders that accompany that permission to inspect a file. And I don't know what our judicial officers would presume if it were a paraprofessional who is making that request.
Fariba, so I practiced in this area, and then for more than 20 years, I supervised the team. I was the county counsel in Santa Cruz County. So to me, the pre-filing work was broader than records requests. It was somebody with proper training stepping in and assisting a family who had been contacted by the agency.
Dana, I stated 3 stages: pre-filing, JB 180, and then request for records. So 3 separate stages. Just so
I understand that. Mm-hmm. It's the family gathering the documents they need, to birth certificates, school attendance, all of that pre-filing where they have no help and the family is in disarray for many possible reasons. If this group decides that that work is not appropriate for a paraprofessional, then at a minimum, I would like our executive summary or a recommendation to support these pilot programs to get people help pre-filing or to allow appointed counsel the minute the agency makes contact with a family. That's the best answer. Mm-hmm. Our work was trying to fill this gap. So many times a filing would never happen because there was a safety plan that was created because somebody who knew about the work could get in and help the family. So that's my biggest interest, is the pre-filing work. I was always on the fence about allowing paraprofessionals to be in court once a proceeding has started, representing or assisting any interested person. I was on the fence, but I was persuaded to allow that. So my main interest is pre-filing help.
And then I've seen cases here where parents need that type of sort of ministerial and, you know, kind of help get organized work, because again, they're in an emotional upheaval in their family and they're not very functional. Lizzie, did you want to say something and I cut you off?
No, you didn't cut me off at all, but yes, I mean, I appreciate Ms. McRae's comments and agree that the pre-filing work is the wave of the future. It is very important and it can prevent involvement in the child welfare system. And I love the idea of supporting it as an extension of the appointment of counsel, which makes far more sense to me than creating this paraprofessional practice. And the first person who spoke during public comment talked about parents who are predominantly very low income. And I would, you know, being in a system where there's no fee cap, where they're entitled to free counsel once they get to court, they are very right. They're in the worst. They're facing what might be potentially the worst day of their life, with this fear that their children will be taken away from them. So I think they're extremely vulnerable to signing on the dotted line and spending a whole lot of money that may have no positive impact on their ultimate goal, or just because it can't. For example, I mean, not that the person. I will assume the best of intentions of the paraprofessional, but sometimes there's nothing that can be done. And other times, so I just think that it is ripe for taking advantage of the client who is in a very desperate situation. So I would worry about that, which is, you know, one of the reasons that our system in California, where we do guarantee counsel, is one that is considered a best practice model nationwide. And I would not want us to unintentionally undermine that component of our system that we should be very proud of. And I think when we were talking about expertise, that applies pre-filing as well. And I was just trying to jot down just a handful of the areas where we expect someone to have expertise before we would consider them capable or qualified to function independently in this arena. And it's not only the very, very thick Welfare and Institutions Code, which requires an understanding of both state and federal law, but substance abuse, domestic violence, health, mental health, GLBTQ rights, regional center, developmental delays, education, special education, family law, delinquency, probate, guardianship. I mean, I could go on and on and on. The list of areas of expertise is almost endless. And there are new ones. Oh, I forgot the Indian and Child Welfare Act, which is one of the most highly appealed areas of law in our state because it is so often misunderstood or misinterpreted or misapplied. Most frequent, it's an area where there's a very high percentage of successful appeals, I should say. So for all those reasons, I would be very worried about, I think that's another reason to be very careful about the role of the paraprofessional, even in the pre-filing work. I think there's a role for the paraprofessional in concert with an attorney, and someone spoke about trauma, and I think there was 1 hour of one unit of trauma-informed representation. To be truly trauma-informed, one should probably have a clinical degree. And it's a very popular word right now. People talk about being trauma-informed all the time. I think it's overused and undervalued in terms of what it really means to approach the practice from a trauma-informed perspective. And if anything, it's going to be a social worker or, you know, a licensed CSW or an MFCC or someone like that who's going to have more ability to assist the person in distress with managing that situation than someone who's trained in completing the appropriate paperwork and gathering documents. I'm just not sure how far that's going to get them in terms of the ultimate goal of keeping the family together and developing that safety plan.
Thank you, Leslie. Good points. Linda and then Sharon.
I just wanted to mention that Ms. Lee has her hand raised again, and I don't know if you wanted to hear from her, but maybe you want to hear from Sharon first.
Let me hear from Sharon, then we can ask Ms. Lee to comment. Hi, Sharon.
I appreciate that as a committee, we've really limited the prongs to what we're considering independency. But I'm very persuaded by these experts, by Leslie, Amanda, and Min Young. a long time ago, I actually clerked for a dependency court judge, and I know that these cases are very, very complicated, and that the attorneys involved really at every juncture are at the top of their field. They're experts. These are not general baby attorneys that are going in without extensive training. And I just looked at the training that we're proposing to stand up a program, and I don't think that dependency, even these limited tasks, belongs in a pilot program. That's just where I stand.
So let me ask you, to Dana's point, that these parents just need some help to organize themselves. And what I'm understanding to be the highest risk being that paraprofessionals just do not know how to interact with the social worker at the FCS and how to represent their parents. Would we want to limit, well, let me ask our speakers if they think the risk would be much less if we just allow the paraprofessional to do some of that work. It's not outside of court, it's outside of no communication with DFCS, and whether we think that's even possible to limit it like that, Dana.
No, I certainly believe that somebody properly trained could assist a family pre-filing. I wouldn't have them not be able to speak to the agency. I don't think that's helpful. I do think that because we've already carved out such a tiny area for dependency, and I think we're going to carve it even more today, and it's going to be really small if anything survives today. If anything survives today, my view would be they have to be a paraprofessional that qualified themselves through family law, and that the family law training include a piece, of course, the 1 unit trauma informed, and I know that that's inadequate, but that's where we are. And then it include the language understanding, a general understanding of the kind of work that would happen pre-filing. And then your family law paraprofessional would be able to do all of the family law tasks and the pre-filing work, because nobody is going to go get a separate paraprofessional dependency license just to do pre-filing work.
Can I ask Dana a question?
Who is that?
This is Sharon.
Oh, Sharon, yes.
Raise my hand, sorry.
No problem.
Bad etiquette. Is this really like an appropriate role for a paraprofessional? Like there's no doubt that that is a need, but is that really what we envision for paraprofessionals? So they're going to have all the trauma-informed care. This is not really filling out forms. This is something beyond that. This is something that, an attorney would do, or even like it's almost social working. Like, I just don't know if we are trying to solve a justice problem with the wrong tool. And that's,
I think that right now what we have in Santa Cruz is a peer program. So they're usually moms. They went through the system. They were either successful and reunited or didn't. And they've signed up as volunteers. And they are matched up with families pre-filing and post-filing. And this is exactly the kind of thing they're doing. Oh, I wish I had had a file on my child's education. And they're trying to help these people. So they're completely untrained, but experienced. They've been through the system. My instinct was to not, when we voted very early on, my instinct was to not allow any dependency work at all in our program. And my strong memory is Fariba agreed. And then I was asked to go out and bring in some experts. I used Ruby Marquez, who was several years at Lacey. I know, Amanda, you know her, before she joined the Santa Cruz County Council's office. And I was persuaded about the pre-filing work. I'm not wed to it, but I definitely see a need. And I really believe that some filings would be avoided if these families had some kind of help that does not exist today.
Mm-hmm. Mm-hmm.
Can I make a comment about the people with lived experience?
Go ahead.
What Ms. McCrae is speaking of, are what we call parent partners, or in the youth arena, we call them peer advocates. So people with lived experience who went through the foster care system, either as a parent or a child, that do work very closely with people who are at risk of having a case filed or have had a case filed. And while they may not have the same, or they may even have less training than the proposed paraprofessional training, they have this lived experience, which counts in ways that are unmeasurable in good ways. And we've had peer advocates at CLC for 10 years. We were the first children's law office to hire peer advocates. And it's the relationship that is based on this shared experience, I believe, that makes them so effective, because there's a trust there that is very different than when you're bringing in someone with, whether it's a law degree, a paraprofessional, an MSW, whatever it is. So I think I see the point about the parent partners not having extensive legal training, but they bring something else to the table that you won't find in a lawyer or a paraprofessional, in terms of their experience and their ability to establish trust and build a relationship that then gives the parent or the youth, the strength, the courage, the conviction, the commitment, whatever it might be, to move forward and embrace that safety plan, or whatever it is that's been devised in conjunction with the parent partner. And I think that I think it's an apples and oranges comparison, though, to say that a paraprofessional is like a parent partner. They may be similar in terms of skill or training, but they're not going to be similar in terms of impact in that parent's moment of distress, when they need to maybe to look at their situation differently and approach it a different way. So I would not see them as interchangeable, and I would think that the skill that the parent partner brings is just uniquely different than one would get from a paraprofessional trying to achieve the same goal. Or a lawyer, for that matter.
Thank you, Leslie. So I'm looking at the time. My goal was to finish at 4, but on this topic, this is important. Steve, I want to make sure because the minors council issue is really simple. We'll do it before you have to leave at 4:15, but I don't want to cut off the conversation because this is really important.
I can stretch it out to 4:30, 4:40 at the latest.
Oh, okay. So I want to still talk about the pre-filing stage. I think it was more effective discussion if we just take it stage by stage. And I still want us to consider if there's any way to allow for any assistance, limited even further at pre-filing stage. And I want to also add the layer of complication when we're looking at separated parents, not necessarily with a case in family court, but they're not together. And now you got 2 parents that are not a united front. And I think I've seen those cases. Please tell me if I'm wrong, but I think they would be approaching the pre-filing or handling the pre-filing stage on their own, and is now adversarial with the other parent, not as a united front. Am I correct, Leslie and Amanda? And Dana, since you've done that work?
So, I think that you raise a great point. Even if the parents appear to be united at the pre-filing stage, having one paraprofessional assist 2 parents is ripe for creating a whole other set of problems if there is a filing and it turns out that the allegations against one parent are much different than the ones against the other, who might even be non-offending. And now they've shared potentially, quasi-confidential information with the same paraprofessional. They thought they were united. They come to court and find out that they're to be pitted against each other. So I would think that would need to be added to your requirements, that if there is a paraprofessional, they can only have one client in the same. A basic conflict check would prevent an attorney, of course, from assisting both parents together. They would only be able to assist in a traditional analysis of conflicts. They would only represent or work with one of the 2 parents, and each parent would have their own attorney. And so I would think would need their own separate paraprofessional. So I think that's an important problem area.
And I know Leah has a question, but let me hear from Amanda and then we'll go to Leah.
I would agree with Leslie's comments. I think that if you have parents that are separated or separating or having some sort of tension and they're trying to do some pre-filing work and get some assistance with that, it's just ripe for conflict, confusion, and I mean conflict in the legal sense. There may be a legal conflict for the person helping them, but also just conflict between the parents and trying to work towards something. I'm also curious what those two parents would be working toward in a pre-filing posture, because likely they would not be filing anything. It's in our dependency cases, it's the county agency that is the petitioner. They file the initial petition to open a case. And so I'm not sure what those parents would be working towards, whether it was creating a safety plan or just trying to look out for protect their own legal interests and keep their family together. But if it's parents who are already having difficulties, that is going to be challenging for one person without extensive legal training to handle.
Thank you, Amanda. Leah?
I just wanted to point out or raise or see if this impacts the conversation at all. Just like this discussion we're having about conflicts, those of you on the working group know that that is being kind of fully addressed by the rules of professional conduct that have been drafted, the proposed rules for paraprofessionals. So I think we understand that there will be conflict checking requirements, but also with respect to the training that these paraprofessionals would have to undergo in order to get licensed, anything related to a dependency sort of scope of license has not yet been built out. So I think if this was approved as a practice area, an authorized practice area, there would be a corresponding specific training requirement. So I just wanted to kind of raise that and not have people thinking that we believe that the generic family law training requirement would necessarily apply. So that trauma-informed representation that you mentioned, Leslie, that's going to be a requirement for all paraprofessionals, but then there are practice-specific requirements as well.
Thank you.
Yeah, thanks, Leah. That's a great point that we haven't really solidified those requirements yet. Okay, any other comments regarding pre-filing from some committee members? Oh, Sharon, you have your hand up. You're on mute. You're on mute.
Sorry about that. Just a quick comment to remind everyone that the other states that have developed an LLLT program or paraprofessional program, none of them have adopted dependency as part of their programs. And I'd like to think that that's for a reason. So that is my first point. And Fariba, I think you were going to call on Min Young. So just a friendly reminder.
Thank you so much. Yes, thank you, Sharon. Yes, Linda, could you allow her to comment? Min Young, you have a comment to make?
Yes, thank you so much for allowing me to speak again. I understand the importance of the pre-filing stages and all of the issues that have been raised. My concern, as I addressed in my public comment, is really the for-profit part of it. And when you're talking about families who are really in that kind of stage where they're frightened and they don't know what to do, I think it's very important that it's not only that there's going to be a charge, but also that there's no caps to that charge. And so I do think that it's really prime for just predatory practices to occur during that stage. Additionally, I would like to also talk about a little bit about how County Council, how DCFS, and how other child welfare agencies are really going to interact with these new paraprofessionals. Like, you know, attorneys sometimes have a really hard time engaging with social workers, depending on who they are. Sometimes they refuse to speak with attorneys at all unless County Council is present. And so when you're talking about pre-filing stages, what is that level of interaction going to be? And how can you assure that a social worker will actually, in fact, engage with a paraprofessional unless that's written into a new training and regulation guide for the entire child welfare system, whatever agency that might be? And I think that's an important fact to consider. And I know that you probably won't have some time for me to address some of the other points, but the one thing that I do want to just address, Mr. Hamilton sort of addressed the idea of being able to represent parties or interested persons and who are not parties through via joinder. And really, I'm a little bit confused by that idea because, you know, relatives or, you know, other interested persons just simply don't have standing. They, you know, in fact, a lot of times can't even enter the courtroom unless the judge specifically allows for them to be in the audience. So the idea that they would hire and pay somebody and then not even be able to sit in on the proceedings, much less say anything in the proceedings, seems to me just, it doesn't seem to make any sense to do that. So I'm wondering, you know, even if they were to file a joinder, and quite frankly, in my, if my experience has been that generally the joinders are limited to very specific agencies that have some sort of interest for the minor child who's involved in the system and not just any relative who wants to be joined to a case. And so I'm just wondering what purpose that would serve for paraprofessionals to be able to do that. Thank you so much for your time.
Thank you for your comments. Just clarification point, are joinders possible in juvenile dependency cases, or are we talking about JV 180?
The only time I've ever seen a joinder in my 30 years is when either the county or the Minors Council files a motion to join an agency that has a legal obligation to provide services to the child. So for example, we'll file a joinder so that regional center or a school district has to come to court to explain why they're not providing services to the child to which they're entitled.
Okay. And also, Min Young mentioned about interaction between paraprofessionals and other stakeholders and whether the stakeholders will even acknowledge. If there are any statutes that right now say attorneys or the FCS, for example, can communicate with attorneys, with parents' attorneys. I believe that if we authorize work that requires statutory change to allow that communication to also be with a paraprofessional, I think, Leah, if I'm not mistaken, I think that'll happen, right? It'll be on a list of statutes that have to be changed to allow for this.
Right.
Okay. So hopefully that.
I'm not aware of any statute, but there's a lot of DCFS policy that tells them not to talk to parents' attorneys, not to talk to children's attorneys without specific consent from county council or in relation to certain subject areas. There's policy and there's state guidance from CDSS,
okay.
The California Department of Social Services.
Okay.
And I think to the 827 issue that Mr. Hamilton had raised, I'm glad that that was brought back up because it was, I understand the conundrum of the parent of a share, you know, a half sibling, for example, who wants the records that relate to the child that is not their own, that is not theirs. And it was couched in the context of there's an issue between the two parents. And I think it's important to remember 827 is there to protect the privacy of the victim child, not one parent or the other parent. It's about the child's privacy. And so there would still be the same process, and regardless of whether there's a paraprofessional filing the papers or not, in terms of all the represented parties having an opportunity to object to the disclosure of the records and the need for the in-court review and all the things that Amanda mentioned as well.
Okay. Steve, did you want to respond to that?
Yeah, and I wasn't sure how the third parties have their voice heard in court. That was, I threw out the joinder because I know that's what we would do in family law, in family court. Is it possible for, let's say a grandparent has not been brought in the case, can they permissibly seek joinder if they claim that they had custody of the child or de facto custody of the child before the dependency proceeding was filed?
They wouldn't typically need to. They would file, well, what should happen, best practice, the social worker would talk to them and would include their information in the court report and would hopefully bring them, you know, would place the child with them. That's the best scenario. But if that doesn't happen, the JV 180, which was mentioned earlier, is the vehicle by which they make themselves known to the court and to all of the attorneys. And then the court would determine if they wanted to order the social worker, for example, to go do a home study and determine if they are a suitable placement for the child or if they should be involved in the child's life in some way. There's also some, to use the grandparent example, there are grandparents' rights around visitation, and the JV 180 would be the vehicle.
Okay.
So Yeah.
My next question is for both Amanda and Leslie. Do either of you perceive there being an access to justice issue with persons who are not entitled to counsel, either because it's pre-filing or it's post-filing and they are not a statutory party? Is there an actual issue that either of you have perceived where they're not getting the assistance that they need? We may have come up with a solution for a problem that doesn't exist. And given the comments that we're hearing, it's causing me to rethink what we've done already or suggested already.
Amanda, do you want to go first? Do you want me?
I was thinking about that because I think access to justice is, of course, of a paramount importance. And where I'm stuck a little bit is that in our cases, we have done very well, I think, in dependency, trying to eliminate barriers to justice in that all parties do have access to competent appointed counsel. And anyone who is interested, we've talked about filing a JV 180, anyone who is interested is permitted to file that. And it's supposed to be liberally construed by the court, understanding that these are often non-lawyers who are filling out these forms and that they should get a chance to at least get before a judge and have their voice heard. So I'm not sure that in talking about JV 180s or in getting relatives access to the courts, there is this type of access to justice issue which would be solved. I think that there are problems in our system. So for example, relatives are supposed to receive notice when a case is filed so that they can present themselves to the court, so that they can get engaged. That's already in our law, and sometimes that is not always followed through on. So there's a problem there, but I don't know if it's specific to someone having the ability to file paperwork, for example.
Yeah, I mean, I think I agree that we have laws that are not fully implemented. And if the laws that are on the books were fully implemented, every relative who has an interest in a child would be known to the court, to all the lawyers, to all the parties, and to the social worker, and would get the appropriate attention so that they could be a resource to the child and the family. So whether a paraprofessional will solve that problem, I don't know. I think that, if there's what we need is enforcement of the current laws with regard to identifying relatives and providing them information about court hearings so that they can show up or show up physically or by filing that JV 180. And whether it's a public information campaign or more accountability and auditing of the efforts made by the agency to reach out and identify and locate relatives, or legislation that strengthens the mandates about locating relatives. All of those things would be welcome by our organization, I think by all the lawyer groups I can think of. But I think the question is, will this solve that problem from my perspective?
I think that's a great question, Steve. And I wanted to ask the same question. So we have three distinct areas. I just want to repeat. How about requests for records, 827 petitions? There are judicial counsel forms. Is there an access issue? Is there a gap there where paraprofessionals could come in and help? Because this doesn't require any kind of litigation or communication with DFCS. This is simply helping someone fill out the forms. And I do take the comment seriously that without fee caps, bad actors can charge a lot of money for filling out these forms that are maybe relatively easy to fill out. But should we give folks a choice to hire paraprofessionals if they want to? So is there a gap there? Amanda and then Leslie.
Just regarding 827s, as Leslie indicated before, any party to the case, so a youth or the parent, they are entitled to their records. And so they can just show up at court, they can show up at, in our county, it's DFCS, and say, here I am, I would like to get access. They may have to fill out a form at that time, but they should not have to file a motion with the court in order to get access to their own records. So when we're talking about 827s, we're really talking about other individuals who are not parties to the case, or someone who is a party to the case who wants to release that information for some purpose. And there, I think that we do have to be very careful about how that information is released. We do want to protect the children who are the subject of these petitions, and not create an avenue for like anyone to be able to access their very personal, private, confidential information.
Okay, Leslie?
Same.
Same.
I don't have anything to add.
Okay. Linda, you have your hand up, and then I want to take the temperature of the room because I want to hear from subcommittee members who haven't spoken. I really want to know what you think. Linda.
Yes, I just wanted to go back to the original Justice Gap, the California Justice Gap study, and questions were asked about custody and child protective services. And in terms of the top 3 problems reported, among the top 3 was investigation by child protective services. People did not include, there were questions about whether people were subject to an attempt for child protective services to terminate parental rights or being involved in a court hearing. Those were not among the top problems reported. But this investigation by child protective services was among the top problems reported. And so I think that's why this pre-filing was originally what was brought in. And I think there were further discussions that led to consideration of representation for people who aren't entitled to appointed counsel, but that was not identified in the study.
True. Okay, I'm going to invite subcommittee members who haven't spoken today, if you have anything to share.
Hi, I was going to say, hi, I'm Monica Wiley. I'm a judge in San Francisco, and I do some dependency work, but primarily juvenile justice and family law. I'm satisfied based upon, my knowledge of the area and the discussion here today with respect to paraprofessionals being useful in pre-filing work. I think that to me is a gap that unfortunately until they get to court to be appointed and assigned an attorney to begin working with them, I think there are some things that a paraprofessional can do. And at least in San Francisco, we have a very active agency that tries to prevent the need for a petition being filed in the first place. And so there's a lot of family maintenance work that happens and that occurs. And I think it may be helpful for a paraprofessional at some stage in that process to reach out to the family, contact the family, and try to come up with a case plan that will satisfy the agency. JV 180s, I think, it's a fairly standard form. And I do agree that courts do liberally allow those to be filed and allow someone to come into court to argue whatever the change of order is. So I'm a little less concerned about that. And the 827s, I think, are a little bit more technical, but again, I look at the court as being really the arbiter in terms of what records are going to be released and to whom. So I think we've narrowly, at least from my perspective, the subcommittee has done a fairly good job in narrowly tailoring what they believe potential dependency counsel or paraprofessionals in that role can do. So I want to thank both of you for coming today and providing your expertise to us as well. Thank you.
Thanks, Judge Wiley. I think Elizabeth, you're the only one who haven't. Do you have anything to share? Be interested to hear it. You don't have to, but.
I don't have that much besides what the experts have come in and told us, but I would not have anything to add. Thank you.
Okay. The last thing I want to mention is again, the comment about no fee caps. And I've interacted with parents in pre-filing and also post-filing, and they are even more susceptible than our regular population with regards to being desperate. And I could see them paying anything pre-filing for that case not to be filed and to get some help. And I am concerned that there may be some abuses. Do we want to consider, if we as a group want to propose that pre-filing assistance be provided, do we want to consider, I know the default position of the full work group is no fee caps, but do we want to consider for this particular work having a fee cap? Any opinions? Sharon, you're on mute.
I keep on doing that. Fariba, I think that you beautifully expressed my sentiments. Like, I am really, really concerned. I'll tell you that if I was being investigated, it doesn't matter if I didn't have money, I'd probably sell off a kidney, right? I'm being sarcastic. Like, I think that people in that kind of desperate situation are going to be susceptible to paying very, very high fees. And the fact that, you know, these procedures are confidential, how would we know? How would we police that? So I'm just really concerned. Mm-hmm. I don't know how we would create fee caps just for this very narrow area when the entire committee has voted to not include fee caps for the rest of the paraprofessional program.
I believe subcommittees are free to propose fee caps for their own area, right?
Yeah. I'm looking at the resolution, and it does not allow for that. Whereas the resolution that was adopted for in-court representation specifically allowed for subcommittees to offer, with some rationale to offer a variation. That's not provided for on the topic of fee cap.
Okay, well, never mind then. So Linda, if you could, just a point of order, and Leah, where do we go from here? Because we don't take a vote in the subcommittee, right?
Well, I think Leslie has her hand.
Oh,
I'm sorry,
Leslie. It falls.
That's okay.
Logo, so
I don't want to interfere with your process, but I was wanted to react to one thing that Judge Wiley said about pre-filing work. And the inference was that the agency would somehow notify the paraprofessional that there was an investigation, if I understood that correctly, and would reach out to these entities that were doing some sort of a pre-filing project. If we could get the agency to notify us when they're investigating clients, we would be more than happy to provide them with free services pre-filing. I'll just give it, I didn't bring this up because it was very micro, but we have a grant funded project at CLC where we do pre-filing work with our teen clients. They're already our client. They become pregnant. In an effort to prevent their own baby from being taken from them, we do essentially what would be called a pre-filing program. But we can't get the agency to tell us that they're investigating our client or what their plan is. So I think that the idea of somebody who has in a professional capacity that can assist families pre-filing, we are all 100% in support of that. I mean, all the lawyer groups are. So that maybe the real solution there is to require some sort of a notification and opening up the work for the lawyers, perhaps in conjunction with paraprofessionals if the committee decides to go that way. But it would seem very ironic to me to have a paraprofessional have more access to information than a willing attorney who's going to provide a free service.
And if I could add some anecdotal information, when I have a family law client who informs me that they've been contacted by a CWS or CPS investigator, the investigators will not allow me to participate or be present in interviews. So there's no services for me to offer other than to counsel them about what they should or shouldn't do.
So can we train paraprofessional enough to do that work?
But why would a paraprofessional have the ability to do that when a lawyer is excluded? That's what I don't understand. I
think she meant whether they would be able to counsel the party about how to interact with the CWS or CPS.
Oh, I see.
I'll kind of tell you where I'm leaning on this. I'm leaning towards this maybe is not the right thing to include in round one without a demonstrated need in order to improve access to justice and the amount of commentary we're getting from the people that are specialists in this field. And I'm already concerned that we've included provisions in our adoptions that are going to make this a very controversial piece of legislation when it's introduced. And I think inclusion of the dependency related issues is just going to add another constituency that's going to be out there opposing the legislation when it's introduced. And so for practical reasons, pragmatic reasons, and based on a demonstrated lack of need, I'm leaning towards now having a proposal that paraprofessionals not provide any services in the area of dependency, including not advising individuals with regards to pre-investigation matters.
So nothing at all, no pre-filing, no request to change, and no request for, in none of the 3 areas we've identified.
I'm thinking eliminate it, and then after a year or 2 of the program being successful, then it would be, because we could get some anecdotal information by then as to whether or not there are people that now that they know that there's paraprofessionals out there, they would have used them, could have afforded a paraprofessional, couldn't afford an attorney, and this is how they were damaged by it. I think what we would get better information and not, again, create an area that will become, the people that we're hearing from today, both in public comment and our speakers today, are not commenting about the other provisions that we've already adopted. And I think that for practical reasons, anything we can do to minimize the number of stakeholders that are opposed to our recommendations when they're introduced as legislation is a good idea.
Okay. So the way I see it, we have 2 possible positions, obviously. One is to provide assistance in those 3 areas, as in maybe not in, if I heard Judge Wiley correctly, maybe not necessarily in the JV 180 and the request for records, but definitely in the pre-filing. And then the other position is not to provide assistance in any of the areas. I'm not hearing another position, which is not pre-filing, but JV 180 and records. So I don't want to make it too complicated. So would you be comfortable, members of the subcommittee, telling me if you agree with Steve Hamilton's position?
I agree with Steve Hamilton's position.
Okay, Dana?
I am not comfortable disagreeing with Judge Wiley. But I am leaning toward no dependency, but not because Stephen Hamilton, who I enormously respect, said there's not a demonstrated need. Linda just explained to us that there is a demonstrated need for pre-filing help. My position right now is that dependency is so unique. And if we're only carving out that little tiny area, I just don't see us being able to require the necessary education for the family law practitioner to pick up this one tiny piece. I am sad about it, but I think practically we're not in a place to recommend the pre-filing work.
Elizabeth?
I would abstain from any vote, but I again respect everyone's decision, and I will leave it to you guys.
So Dana basically said what I wanted to say. Thank you. While I agree with Judge Wiley and the Justice Gap study kind of confirms that there is a need, and I see the need. I also see it in the JV 180 area, but again, I'm not too concerned because again, standards are really low. Check a couple boxes, get in court, they'll address it. As I think Judge Wiley sort of said the same thing as well, and Amanda and Leslie. I agree with Judge Wiley that, again, we just got that there's a need, but I just think we need to table this thing, work on it some more, see if the pilot projects develop in every county and just get more comments and not rush. Judge Wiley, what do you think about that?
And I'm fine to bend to the will of the majority of the group. I do think that perhaps it's an issue that needs to be studied a little further to have a demonstrated need. How we do that, whether there's a survey or something that we can do in the future to ascertain that as we move along with the pilot project. Perhaps that's something we can look at. I do agree with Ms. McRae in terms of if we're just going to have this very, very narrow, tiny part, then we may not have any paraprofessionals who are willing to undergo the additional training and education for that one very, very small slice. So I agree that it might be that we create this vehicle, and unfortunately we don't have people who are willing to do it. So I'm fine with being and presenting a united recommendation with respect to dependency.
Okay, so I think we have a consensus that we're going to table this issue. All right.
We're not tabling it. What we're doing is we're proposing a bylaw that
okay.
Linda's here. Linda would type up that says that the scope of services by paraprofessionals will not include services related to dependency proceedings, including pre-filing actions.
Well,
okay.
I don't know that we need to do that because as of now, dependency has not been adopted. And so I think if it hasn't been included, because it wasn't taken up at the last meeting, they just decided not to take it up. So we can, whatever we put together for a new memo from this, that comes out of this meeting, because there are some other issues, I think we can just say in there that the subcommittee decided not to include any representation in juvenile dependency cases. But I don't know that the working group as a whole needs to take any action on that.
Linda, the table that exists of the tasks that we outlined that was going to be included with the resolution adopted for family law services, it didn't include any discussion of, did we strike the dependency language that was in there?
Take a look.
Well, I think what happened was that the resolutions that were adopted specifically were for different practice areas. There was family, there was violence prevention, and they addressed each of those specifically.
I don't see anything on dependency.
Okay, then I stand corrected. Your tabling suggestion is beautiful. It's wonderful for Eva.
All right. Well, thank you, Amanda. Leslie, your hand is up. Is it a new from the—
No, it's not. It's not new. But I'll very quickly thank you so much for taking our thoughts seriously, and would also just offer that if there's a future opportunity to dig deeper, that I'd be more than happy to participate in any conversations. Thank you.
That's really good to know. Thank you. Thank you, Amanda. And
thank
you.
You
have a question for our speakers, or just Sharon? Did you have a question?
No, just I think Brady was raising his hand, and also this was a really good conversation. So thank you, everyone. And thank
Brady,
you.
do you have a question for our speakers, or can I let them go?
You can let them go.
Okay. Thank you, Leslie and Amanda. Thank you so much.
Thank you so much.
All right. So Brady.
So I just wanted to, sorry, our internet in the building is down, so I had to dial in from the phone. So I wasn't a panelist initially, but my understanding, I'm trying to pull them up. I thought the resolution passed basically was very inclusive, that said all family matters, family law matters, including but not limited to those listed on, it was Appendix B of, I believe, April or March memo. So that table that Stephen was talking about, I believe that was passed in a resolution at the June 10th meeting as the family law group.
So well, I can review that, but if you look at that attachment, there are separate tables. There's one for family, there's one for conservatorship and guardianship, there's one for dependency.
Dependency is not family.
So
right, dependency is separate from family. There's a one for child welfare.
But we voted separately on each one, and we didn't vote on conservatorship guardianship, which we voted on just as at the meeting on Friday, and we didn't vote on child welfare until we had this discussion, and then we were going to vote on it.
Yeah.
Well, I guess, and this is something that we're looking at as we evaluate what we've done. I guess there's some question in my mind what it means to say all family law matters are included, because I don't know how family law is defined if it doesn't include.
It doesn't.
It
doesn't. It's the welfare institutions code, not the family code.
Yeah, there's only half an hour left for this meeting.
Gotcha.
I think they have another agenda item, so I think we can figure that out
offline. Sorry.
and figure out
Family law on the chart has its own section, just letting you know. Okay.
Linda, you know how you've got the Dropbox folder with all of our stuff and materials in it? Would you be able to create a resolutions folder so we can see all of the adopted resolutions? Is that feasible?
It's in there. It's in there. It's under the meeting materials folder.
Okay, so
there's a meeting materials folder and full working group, and there's adopted resolutions.
Oh, meetings of the full. Okay, gotcha. It's a subfolder.
Okay.
And I have Stephen's. I can bring this up. The resolution that Stephen put in his memo.
So under other items remaining, I'm just gonna go to Minors Council first. And Steve, after that, I hope you can stay, but if you have to leave, we understand.
I got fireworks to sell.
Oh,
what?
Fireworks. I'm in the Knights of Columbus, and every third year, my council gets to sell fireworks to raise money for our donations. And today is the day that one of the days I'm working in the booth, so I got to be.
Okay.
Isn't that illegal?
Do we get a discount if we come? Do we get a discount if we come to you right now?
Yes, you come down. It's in Arroyo Grande, Log Cabin Market. Be my guest.
It's a short drive.
Yeah.
Okay. So, Steve, go ahead with this.
Okay, yeah. So this issue came up. You heard Andrew Kane's name mentioned before. I probably shouldn't have included the reference to him as a rock star in the area of advocating for children when I read, in light of the fact that the memo was going to be published. But he truly is. He is the go-to resource on all things children related in terms of advocacy and representation. And Fariba and I both know him very well, and he is an incredibly intelligent, articulate person. And he raised this issue with Fariba and I as technically under the resolution we adopted, there's no clarity as to whether Minors Council could be a paraprofessional. And it is my position that absolutely not should Minors Council be a paraprofessional. And at first I thought it was, well, Minors Council's got to be an attorney, right? But I went back through Family Code Section 3150. I went through the rules of court, and nowhere in them does it make a specific reference to attorney. It's always phrased in terms of counsel. And while we might colloquially view counsel as always being a member as an attorney, in the statutes it refers to as someone, a member of the bar. And I'm not clear whether a paraprofessional who's going to be licensed by the bar is going to be considered to be a member of the bar as well. So I just wanted to clear this issue up. Having represented minors for probably about 12 years, then I started teaching counsel how to represent minors because there was a dearth of courses. So I ran a program in San Luis Obispo for 4 consecutive years where we trained. At the end, we had 150 lawyers showing up from throughout the state. I would say I'm very well versed on the issues of Minors Council. The education and training required is completely inconsistent with what we've recommended for paraprofessionals. And therefore, I'm proposing the resolution that's on the screen. And I'd be happy to address any comments or questions that members of the subcommittee have.
Thank you, Steve. And I agree, especially because the kids in these types of cases are at-risk children. And throughout our resolutions, we have excluded work involving at-risk children and children's safety issues. So to remain consistent, I think we need to pass this, to propose this resolution. Members of the subcommittee, anybody have any comments? Please raise your hands or just speak up. There's only a few of us. Sharon.
I would also agree. And I also agree that Andrew Kane is a rock star. I worked with him a very long time ago when I worked in Santa Clara County.
Okay. I think we could probably just go to a vote on this. Anyone else?
Move approval.
Yeah, let's call the question and move for discussion to end.
Thank you. I second Dana's first. I don't think we take votes like that here. I know, Linda.
Do we need to take a vote if there's a general consensus?
This is the resolution that needs to be presented and on the agenda for our next meeting as a whole, with the wholehearted endorsement of the Family Law Subcommittee.
I think we agree, and I think we could just do it.
Okay.
Thank you. Thank you, Steve. So we have the education requirement. Let me see if that, another quick one. With violence prevention work, when we, our proposal that was approved in the June 10th meeting, unfortunately, we left out elder abuse, even though in all of our discussions, we had included elder abuse. And procedurally, I think we have to propose an amended resolution, right, Linda? Or just, how do we do this?
Well, I think so, because that one does specifically refer to violence prevention as listed in that appendix, in that attachment B. And since, as you discovered, elder abuse was not included, we would need to amend that. So if that's something that you want to do, if there's agreement, again, I can just include that in my memo. I don't think we need a motion unless there's disagreement.
Okay, so anybody want to disagree with that? Raise your hand now. All right. So it's good to go. Let's do an add. Okay, cool. So we have the 3 items left. Educational requirements, informed consent, and disclosure language that we want to add. It is 438, and I kind of spotted an issue with regards to enforcement of judgments. That is, if someone wants to hire a paraprofessional to enforce a child support judgment versus go to the CSS, which they have the freedom to do, then we have a whole set of private child support corrector legislation that kicks in. That's different from our this set of requirements. And I wanted to just point that out and talk about whether we need to sort of recognize that and say the paraprofessional is to follow both sets of rules, and if there are any inconsistencies, they're to comply with the more restrictive rules. I don't know if this is such a quick discussion. We can certainly hold that for now and put it, maybe have another meeting another time, or I was going to bring it up in the, maybe as a discussion topic for the full group to create a separate legal specialization, if I may call it that, as enforcement of judgments, because it crosses over in the different areas. Any quick comments from anyone, preferences? Justice Petrel, what do you think?
I'm trying to think about whether that makes sense to have it be an entirely separate thing. I don't have at the tip of my, I don't have at my fingertips right now in what areas, what resolutions we've passed regarding enforcement of judgment and how it would be different here. Leah?
Yeah, Fariba, I believe you've raised this in the regulations.
I did.
And I think that's where we address it, is in the rules of professional conduct, because Greg has talked to us quite a bit about those circumstances where someone is acting within an authorized scope of practice, but perhaps could choose to opt out and be acting under another set of authorizations. And so I think he's kind of identified the solution or what the application of the rules would look like in that context. So I actually think it's better to just bring it back to regulation than
Yeah, I don't think we need to spend time in this group discussing this further.
Yeah.
Okay, good. So that was another quick one. That leaves us with education and informed consent. Which one do we want to take up? Because we only have like 20 minutes.
I would suggest informed consent because it will help you all in regulation, Fariba.
Okay, so
education, yeah, we have a little bit more time.
Okay, could we put that up, please? The pre-consultation disclosures and informed consent, to see if we want to add any language to it for family law.
Oh, you mean what's already been adopted?
Right.
Okay, I have to, that's going to take me a moment.
So basically, so while you do that, that's no problem. Is there any specific disclosure we want to make regarding family law matters. So for example, one of the issues we're discussing, like in housing, we talked about specific disclosures and, for example, providing contact information for housing resources. So I was thinking, even though my general position is I don't want to create a burden on paraprofessionals to have updated, detailed contact information for every area of law that you're authorizing them to do. Do we want to do that for family and just limit it somehow? I'm really concerned about the undue hardship that would create to have them have a list of local resources that would provide free services, legal services, and then keep that list updated versus a simple referral, for example, to state bar legal resources. Any of you have any? I'm going to start it there. Anybody have any position on that?
I don't know, Fariba, if it's as burdensome as one would think. Usually, like in any given county, you have like, even in Los Angeles, we're a huge county, it's a short list of organizations that provide family law services. And generally, if you are in the business of providing family law services, it doesn't change from year to year. So, having in some of these smaller counties, it may be one organization that may be able to provide assistance for free. And I think that just giving the consumer that choice of like, hey, you're free to look them up, and here's the name, and see if you can get free services, or you can go with my services, your choice, will just make the consumer better informed.
Mm-hmm. So I'm happy to share my office's local resources. It's a whole page long. And like there's at least 7 domestic violence agencies that provide assistance. And I've shared this before that I have to assign an intern when I have one to update the list. And we often find some information is outdated. Anyone else?
I guess I would be interested to know, is there going to be discipline flowing from this if they don't keep it updated, or if they miss a nonprofit, or did they get a warning and an opportunity to cure? And we probably don't know any of that yet.
I think actually Leah.
So Leah, actually, hold on one second. Leah, can you jump in on this? Because I thought, is this not a topic that being discussed in the regulation group, as far as whether it should be something, for example, that we're asking the state bar to maintain, that they can direct people to? I think we've had extensive discussion that it seems fundamentally unfair to ask an individual paraprofessional to somehow keep an updated list on an ongoing basis. I don't even know how someone would do that. So I thought we'd had extensive discussions about the fact that there needs to be somewhere or some way that the paraprofessional could refer a potential client to a website or to a place, but not that the paraprofessional is somehow tasked with keeping an up-to-date list.
Right. So I think at our last full working group meeting, we went over this issue in some detail, although we didn't particularly focus on the 2 different versions of the informed consent rule, one with Fariba and Kim's position, which is that the paraprofessional would not be required to provide any specifics about alternative providers. The other version is Amos's proposal that they would. And so, as you suggest, this has been vetted by the regulation subcommittee. To answer your question, Dana, if it is in the rules of professional conduct, it absolutely is a basis for discipline. And that is why the recommendation of that we're getting from Supreme Court staff, state bar staff that is expert in rule drafting, is that we not include it in the rules. So on that particular issue, there has been a lot of discussion and input by staff that do this work. Linda, we're now seeing your emails. Mm-hmm. So I don't know, Fariba, that's one type of additional informed consent language. Another might be something unique to family law, like, I don't know, a particular risk. associated with family law representation. A good example is in the collection space. The informed consent language will clarify that the paraprofessional cannot bring any action in federal court. So that's a particular risk associated with the collections context. And I don't know if there are others unique to family law that you want to call out. Sort of just moving away from this question of will alternative service providers be listed?
Right. Yeah, we kind of had a robust discussion housing whenever that meeting was yesterday. Gosh, I'm getting my days confused. So that's why I brought it up. Members of the subcommittee, I want to make sure you've had a chance to consider this issue. And if you haven't, I want to give you enough time to consider whether you think we need to add additional requirements, language to the informed consent form for family law. And that includes all of the family law, family, children, custody issues.
I can't think of anything, and I do family law.
Mm-hmm.
And then this is, I mean, because we already have that one statement that says that alternative referral sources are available. I mean, you're saying in addition to what's already listed, is there anything else specific to family law?
Well, we haven't had a vote on number 2 yet. There's 2 positions. So we're going to just not talk about that right now. In regulations, Amos has 1 position. Kim and I have another position. Okay. And so we're just not going to discuss it here right now, maybe later, another meeting. But do we think there should be additional information specific to family law? Mm-hmm. And I'm just wondering if we should not talk about it today, because I just don't think we've had enough of a chance to consider it, or you've considered it and you don't think there should be anything. Because I can't think of anything right now.
Nothing comes to mind for me right now.
Mm-hmm.
Nor for me.
Okay.
Beyond like the scope of practice, right? So there's certain things the family law paraprofessional won't be authorized to do. I'm just thinking of the excluded tasks, but I guess that's already addressed because there is disclosure regarding the limitations of scope. Yeah.
So number 4 covers that, right?
Yeah.
Yeah.
I mean, maybe it doesn't matter here, but like things that sometimes when where other third parties may need to be hired would be things like vendors, process servers, right, in contested cases, or like the quadros, like we're not allowed to do quadros. So maybe we can give you referrals to, again, a third party vendor who, in order for you to divide the property between, you may have to hire, other vendor services.
So the way to look at that is whether we want to require providing that kind of information and have it be a violation of rules of professional conduct and subject to discipline if they don't. Okay,
then no.
Okay. Thanks. Okay. I think number 4 really takes care of a lot of things for me, and it's general, but I just don't think it needs to be specific for family law. So right now I don't have any suggestions, and I don't hear anybody else having any suggestions. Do we have, and we can email staff, right? If we just individually, not copy anyone, right?
Yes, that's correct.
Okay. So that gives us about 10 minutes to talk about education.
Okay, I will bring that up.
So we've been, because we have family law experts on this subcommittee, we've been asked to kind of take a look at the family law or family, children, and custody subtopic and decide whether we think it's sufficient. Do we want to do it a different way? And let me ask you, Leah, is this where we can also talk about, so family 1 and 2, if I'm understanding this correctly, kind of paraprofessional, are we considering to allow a paraprofessional choose to do family law 1, but not family law 2 because they don't want to, for example, do violence prevention work or any of those?
Fariba, let me just interrupt you. Based on our conversation, before I posted the memo, we took out the distinction between family law 1 and family law 2 because you had conveyed to me that you thought that people doing family law needed to be familiar with all those different
So me
areas.
and you discussed it. Okay, I know I had that discussion.
So that might be confusing to people because there was reference to that. So this is what was included in the memo. What I'm showing now, I've stricken dependency law since that's been taken off the table.
Yeah, and I said that because there's a lot of crossover.
Right.
Okay, so, and the other thing I wanted to say that we took out here because it confused me was that 3 units, for example, actually turns out to be, if I'm correctly, in the 135 hours of work, right?
Right. Because the way it's calculated is that for each hour of classroom instruction, there's an expectation that the student will be engaged with the materials for an additional 2 hours. So every unit is actually 3 hours. And if it's 15 weeks and it's 3 hours a week, so that's 9 hours a week of student engagement for 15 weeks. This is assuming a 15-week semester.
Right. So trauma-informed representation, 1 unit actually 45 hours of work, which is considerable.
Yeah.
So what is, just so that and I'm sorry if I wasn't tracking, what is up for discussion at this point?
Whether,
what we're looking for is to provide to the licensing committee the hours to be included in licensing for each practice area.
So Linda, can you clarify which ones had already been developed?
What had originally been developed was just the family law and procedure and advanced family law and procedure, as well as the trauma-informed representation. So what's included in all practice areas has already been adopted by the licensing subcommittee, as well as the first 2 lines for family law. But since
so back to my question of what's up for discussion, does that mean that what's left is the lines that you have for adoption, violence prevention, and conservatorship, guardianship?
Yes.
And can you explain the rationale, Linda, that you used in coming up with like 3 versus 2?
Well, we didn't really have a very strong rationale. I think it was mostly aligning it with what already had been developed by the subcommittee and to have this be a starting point for discussion.
So for example, for adoption, I would question whether adoption would be 3 units as opposed to and comparable with advanced family law practice and in family law and procedure. I don't think you need that many units per se.
I agree.
Adoption. So it's hard in a vacuum. It's kind of hard to decide what's going into these numbers.
Well, and part of it is, I'm somewhat informed by the fact that although I don't teach these classes, I do teach and I've taught for a number of years. And I have a pretty strong sense for how much time, when we're talking about the units and hours and all the rest of it. And Judge Wiley just took the words right out of my mouth or out of my brain, which is, I'm not a member of the subcommittee, but I'm just going to say, I don't see how adoption or why it should be 3. And I also think that 6 units of family law and procedure is a lot, but I leave it to you all to discuss.
It makes it a little difficult because I don't know what's envisioned to be included in advanced family law and procedure versus regular family law. So for example, family law will include custody visitation, but advanced family law will include emergency. Well, they will not handle it, but they need to learn what emergency custody visitation issues are and what takes a custody visitation issue into the emergency area, which they can't touch. So has there been a discussion about course content, rather than just title of the course?
Yes.
I think the course content, oh, go ahead, Leah.
There's been some discussion only about family law. And I think the best people to answer your questions are the folks on the licensing subcommittee. I can't recite it, but I see advanced family law as an extension of family law, kind of like in any other classes, you might take a sequence or a series. So it's a continuation of the series. I do know that in licensing, and what has been presented to the full working group, is that family law is the most complex area that is going to be authorized for the paraprofessional period. So when we try to come up with these other sort of unit requirements for other practice areas, we try to benchmark them to family law, exactly what the justice and the judge just did, and just basically say, oh, that's too much for adoption in comparison to family law. We're taking as an assumption this idea that family law is going to be the most rigorous, and so working from there. But Fariba, like in terms of building out the learning objectives for each of these, some of that has been done, as I said, for family law, but for these others, because we don't have experts in general on the working group in many of these areas, our staff recommendation is that the working group come up with unit requirements, and then the state bar engage subject matter experts to develop the learning objectives.
And I just want to toss in the idea, and I know that's already been approved, family law and advanced family law, but I don't know if that's what we really mean. I mean, piggybacking off of what Leah just said, it sounds like the point is this is a complicated area, and you're not going to get it done in one class in one semester. You need the equivalent of 2 full classes over the course of 2 semesters. So I just want to throw out there whether you really should be having 2 line items here, or whether it really should simply be family law and procedure 6 units, which means it's going to take 2 classes. I think that makes more sense. I don't understand this family law and then advanced family law.
And I think it makes it simpler to explain. We don't have to explain it. It's 6 units of family law. One other point I wanted to mention was when I was thinking about having family law 1 and 2 and having some people opt out of, for some family law paraprofessionals opt out of doing specific specialized areas such as adoption and conservatorships and guardianship. And now we're not doing dependency law. I was thinking about the crossover. Now I've thought about it, and I'm just listening to the comments. I'm posing this question. If a paraprofessional, first off, should we, as a way of lessening the burden, should we allow a paraprofessional to say, I just want to do basic family law. I do not want to do adoptions, and I don't want to do conservatorship of guardianship, but we think it's important for them to learn the crossover issues, right? Maybe family law and procedures should, for those who don't want to do the subspecialties, should just cover the basics of adoptions and guardianships, conservatorships, just enough for issue spotting. But if a paraprofessional wants to practice that work, wants to actually, do that work, then they have to take a separate adoption class and a separate conservatorship, guardianship class, which now should be 3 units or not. But what do you think about that idea?
I think our time is up, but I think that I just want to say, I think it gets too complicated. I mean, my gut reaction is that it's too complicated. We're going to have a hard enough time standing up a new program without doing so many, sub variations within areas. I leave it more, I'd be curious to know what Leah and Linda have to think about it, who have more experience in this, but that's just my gut check.
Okay.
Yeah, I have the same reaction. I agree with you in sort of in theory, Fariba. I mean, I actually agree with you, but I think it is too complicated. And I think it's a better business model to have within your scope, to be able to do all of this, even if you think at the outset that you don't necessarily want to. So we should encourage a broader scope of license rather than a narrower one.
Okay. Sharon has her hand up.
Yeah.
Sorry, I'd like to go back to the screen and look at it for a second. In which one of these classes is just basic issue spotting, how to properly do an intake and interview the client? I just want to make sure that that's going to be part of the curriculum. I'm not advocating for a separate class, but just some of those soft skills needs to be absorbed under one of these classes.
Shouldn't that be in all practice areas?
Yeah, I think it's a good note for learning objective, sort of the build out of the learning objectives, but it's broadly applicable, I think.
Right. You know, in the olden days, I don't know if it's still required. Wasn't office management a required CLE unit? Do we think that's obviously it's gone? So I'm assuming that.
Well, maybe it is. Maybe I'm so old in days that I even predate that, and it's come and gone because I don't remember ever having to take anything like that.
But didn't we? Am I imagining it? I thought we did. Dana's shaking her head.
Oh yeah, we did. One unit, office management, MCLE.
Okay. So obviously it's gone and it didn't have any value. But is there value in having a course about intake and interviewing skills?
I don't think we should, and I'm going to take my prerogative to say we should end the meeting because I don't want people, people carve out their time and it's hard to do. So I want to stop it. Not because the conversation isn't interesting or important, but I think we are also veering off into areas that are not really family law specific. And that's why it's helpful to have Linda and Leah here to help us raise it in the appropriate subgroups, because these are all important issues. So thank you, Fariba, for running another meeting. And Linda or Leah, are there any housekeeping matters that you need to bring up before we can go on into our evenings?
No, thank you. I don't think so.
Thank you, everybody.
Thanks, everyone.
Bye.
Thank you. Good to see everyone. Take care.